Welcome to How's Your Life Looking? I am Marian Bennett, a mortgage lender serving Camden County and surrounding areas in Georgia and Florida. I help people make some of the biggest decisions buying homes, but there is so much more into building a life. I'd like to bring in some of the most amazing professionals that I meet on a daily basis, and we discuss everything from mental health to managing finances, empowering you for life decisions to make you build the future you deserve. Today, I'm joined by Chap Sweat, a real estate attorney serving Camden County, Georgia. We had a deep dive conversation on frequently asked questions about real estate law. I hope you found value in it. Enjoy! Chap, what would you share with the community, who you are, what you do, and how you can serve them?
Well, my name's Chap Sweat. I'm the managing and founding partner of the Sweat Law Firm. We're a real estate law firm here in Camden County, Georgia. We focus primarily in real estate transactions, mostly residential. We do some commercial transactions as well. And we also assist clients with wills, probate, those type of situations, estate planning, and also corporate and LLC conversions and creations, formations.
So Chap and I have been working for quite a few years since you're working with another law firm, and I have the honor to work with you and your team and always attend. So thank you so much for serving our personal customers. And today we want to bring you to this podcast because I asked a few questions to the audience and what they would like to hear from an attorney, what questions that they had if they have the opportunity to be in front of a real estate attorney, or whether it's helping them with their life, legal documentation. And I want to thank you for being here. So I have some questions for you.
Sure, ask away.
And I will go over and see if we can discuss it, and we'll share it with everybody that is interested to hear these answers. So in your opinion, what is the most common misconception that people have about the role of the real estate attorney, and how do you set the record straight?
So most people, they don't see what we do in a real estate law office. What we do mostly is in the background, behind the scenes. And when the actual buyers themselves see us, all we do is we come in for the closing and point where to sign on the paperwork, and that's what people think is all that we do. But really there's a lot more that goes on behind the scenes. One important aspect of the job, and it's both the attorney and the paralegal staff that we have, is coordinating all the aspects of a closing. Because you have your job and your responsibilities during a closing. There's real estate agents, there's insurance agents, there's home inspectors. There's all these different aspects of a closing process that all have to come together, and the closing all happens at our office. So we're the ones that are coordinating all those aspects. But for the attorney specifically, our important job is to make sure that when you buy real estate, you're actually buying the property that you think you're buying, and that the seller is the actual owner. That's the really important part. There are some lawyers out there that are point and sign this paper and their job's done, but a really good real estate attorney makes sure that that property that you're buying is actually owned by the seller with no liens, unexpected easements or servitudes, or that's just fancy words for restrictions,
right,
against the property that could affect your ownership of the property down the line, or you being able to sell the property when it ever comes to a time that you want to sell as well.
So very much, when you're buying a home and Mr. Smith owns a home and is in a contract, and then I'm sure you ran to this before, that Mr. Smith is not the only owner, or Mr. Smith used to own a home. So you're doing the proper search to make sure that what they're buying is owned by the individual that owns the home, and meanwhile is a home that is actually clear of title. Mm-hmm. There's no liens or anything that is attached to the property, and you're buying the property with a problem. So you assure them that that's what's happening.
Right. Our real work comes in when the title work comes back and there is a title problem. Mr. Smith says he owns it, but for some reason, whether his fault or not, he actually doesn't own the property by the legal records at the courthouse. And so, like I said, the the buyers may think we're an unnecessary roadblock because all of a sudden we'll come up and say, hey, there's a title problem. We got to get this fixed before we can close. And well, what's this attorney holding things up for? But it is for their benefit to make sure that they're buying property that is actually owned by the person that is selling it. So we go and we get corrective deeds and get things cleared so that we can proceed with the closing.
So through the title search, that's pretty much the process you guys go through, the title search of the property. How far deep do you go on the line of that search?
So for a full title search, you're supposed to go back 50 years from the date of the search, and whoever owns the property exactly 50 years ago, you go back to when that person purchased it. So if you go back 50 years, that's going back to 1974. Whoever owned it in 1974, you find out when they purchased it, and then you start from there. Sometimes someone may have owned it for 40, 50 years in 1974. So in those cases, you're going back to the 1920s. You can go all the way that far back. Hopefully, usually you don't have to go quite so far, but that's the process. You have to run the links in the chain, see where the seller, who they bought it from, and get all the way back to 1974, see when they got it, and then you turn around and run it back out from all those different owners to make sure they never gave a missing interest, that they got the full title every time they purchased the property, and there are no easements or servitudes.
Right. And that's an extremely important step. One of the things that I do encourage our buyers once they are purchasing a home through us is an insurance that it is going to help them protect that search and protect everything. And I would love for you to talk a little bit about that so you can explain to our future buyers or current homeowners that have closed recently that I stress a lot for them to get this insurance. Please, would you be able to go over deeper a little bit about that?
Yeah, so title insurance is a very important thing. It trips a lot of people up because they'll see on their settlement statements that there are two title insurance policies. There's one for the lender, and then there's one for the buyer, and it'll say optional beside it. So it is optional for all the buyers whether or not they want to get a title insurance policy. We strongly recommend it on every closing. And the reason why it doesn't say optional beside the lenders is because the lender is going to require it. They have the option to not get it, but no lender is going to close any closing without that title insurance policy.
Absolutely.
And when you're paying, the title insurance policy for the lender is going to be on the buyer's closing disclosure as a closing cost. But when you're getting that lender's policy, it does give you a break on the cost of the owner's policy. But as we were just talking about, we do a title search for every closing. We try to make sure we find all errors. Just because we did a title search, people are human. Things can get missed. If that happens, the title insurance policy covers it. But even more than that, title insurance covers problems that even the best title search can't discover. There are errors like forged deeds that on their surface look valid, but for various legal reasons are invalid. So you can go back and do a great search, and years later there may be a title problem that pops up despite having that title search. But with your title insurance, you are protected. That policy will protect you up to the purchase price. And in the case of a home, if you're purchasing a primary residence, and not only does it protect you up to the purchase price, but every few years it increases in value a little bit to kind of go with the increase in values of property for inflation and things like that.
And that is the only policy, to my knowledge. They only pay one time in your lifetime, and as long as you own the property, you're protected.
It's great. Yep. So it's a part of your closing costs. So if you get that title insurance policy when you get ready to close, and Miriam tells you what your final cash to close amount's going to be, that policy is included in it. You're never going to pay another premium on that, and you own that as long as you own that property. That policy is going to be in effect.
That's the best insurance that I ever paid, and I would never purchase any property without having that peace of mind. For a couple $100, I have a lifetime peace of mind.
Exactly. Yes. It's the premiums based on the purchase price. The more expensive the property, the more expensive the insurance policy. But for what you're paying, it's extremely cheap insurance for the amount of coverage. It's a couple of $1,000s for $400,000 house, and it lasts for years, decades even.
Thank you for clarifying that. I sometimes I get questioned about, well, we already paying the lender. So I have to explain to them, well, the lender would not, you can actually opt out for having lender insurance, but then the lender will opt out to giving you the loan. So, but no lender is going to give you funds having their property, their lien as a risk. So that's, I stress out, if you're protecting the lender, well, you're not protecting yourself. It's your home at the end of the day.
Right. The lender's getting that policy because they try to assume the worst in every situation because they have lawyers advising them. And so they assume that perhaps the borrower won't make their payments and they lose the property in foreclosure. So they are going to need that title insurance policy in case they ever take control of the property. And just like the lender wants it, because if they ever have ownership, they'll need that policy. You should want it too.
One thing I wanted to ask is, when you come to title insurance, is there are some allowed exceptions that you can have. Can you talk to us a little bit more about that?
Yeah, so when we do the title insurance, or when we do the title examination, like I said, we will find any servitudes, easements against the property, and a lot of them are things that are just standard common things. So like if you have a power line going to your house, there's going to be an easement to the power company for them to come across the property and check those lines. That's a permitted exception. So if you buy the property and then the power man comes onto your property, you can't say, I have a title insurance policy, get off my property. The Georgia Power easement will be accepted from that policy. Right. So easements for utilities, water drainage, like if there's maybe a ditch in the front yard, for water runoff, that, and along with HOA easement or restrictions. So if you're buying property that has an HOA, then you know that there are going to be some rules of the HOA kind of tell you things that you can and can't do out there. That's another permitted exception from you owning full ownership of the whole property. Right. Those are by far the most common ones we have here.
How about surveys?
So the policy will have an exception in there saying anything that's shown on a new survey of the property. Georgia does not require a new survey for every transaction. Other states do. You'd have to pay for a survey every time. In Georgia, if you bought lot 10 in a subdivision and nothing's changed for 15, 20 years, you don't have to get another survey showing that exact same thing again. You can use the older survey and reuse that, which does save buyers in Georgia some money on new surveys. Absolutely. And the surveys will show those easements for like the power company, the HOA, things like that.
It happens often that they ask me this question because they come from Florida. In Florida, you are required to have a survey. And they are like, well, we need a survey. And there's so much stress about it that we haven't ordered a survey. But in Georgia, it's one of the benefits, out of many benefits we have, that we don't require a survey, which just saves them a couple $100 in their closing costs, right? So that's awesome that you brought that up. Now, one thing that some of the audience asks is like the confusion in terminologies in industry. What is the common legal term that confuses clients the most, and how would you explain it in an everyday language to a home buyer?
Yeah, so I think the most common thing that gets confused is what we just talked about, is why is there a lender's title policy and why is there an owner's title policy? Why am I paying for two title policies? So just the easiest way to think about it is the lender's policy is only protecting that lender. If there are any title issues, the lender's protected, but you'd still be out on an island. Whereas if you had your own title policy as well, you are just as protected as the lender is, and it's ultimately your house that you're buying. So you want to be the one that's protected. Just to kind of give some ideas of some things that could happen in a closing process that could, your title insurance could take into effect that, as I said, we do a title search, but it may not find every problem. Some real world things that I've had happen to me. We had a closing one time where it was a very nice, expensive house in a nice neighborhood, and it was originally owned by an elderly woman. She passed away. She had 4 kids. When she passed away, there was a deed done. All 4 kids, they were her 4 legal heirs.
Right.
They signed, there was 4 signatures on the deed. It was recorded. Somebody else bought it. Those people owned it for about 5 or 6 years, and then they were going to sell it, and we were doing that closing. And when we were doing that closing, one of the kids from the original owner called us and said, "Hey, this is the second time Mom's home's closed, and I've never gotten any money from it."
Wow.
And so we sat down with them, and I had them sign on a piece of paper, and then I looked at the deed that had been recorded, and it was clearly his signature had been forged on the deed. Now, doing some investigation, we realized that one of his sisters was kind of a little bit of a crook, and she had forged her 3 siblings' names on a deed and had gotten a fake notary stamp and had it recorded. And so our sellers had bought it from that sister thinking that she had gotten all 4
signatures.
Exactly. So they were completely innocent. They thought they owned the property when really they only owned 1/4 of it because 3 of those signatures were missing. And, when we did our title search, we see 4 signatures recorded at the courthouse.
Right.
So it looks clean to us. If you didn't have title insurance, you're going to have to go after that bad actor sister and try to track her down and get your money back from her, which is never going to happen. She's disappeared. In this case, she was actually in jail at this point for some other crimes she had committed.
Right.
And then, or you'd have to go to those other kids, and if they say, we don't want to sell our interest without you paying me again, now you're paying for the house a second time. Whereas if you have your title insurance policy, the title insurance company says, you don't worry about anything. You sleep in your house in your bed at night, and we will negotiate with those kids. We'll go after the bad actor's sister, and we'll take care of everything. They will offer some money to the other siblings to pay them off and get corrective deeds out of them.
So in this case, so just to give some, numbers, let's say this home costs $200,000 when this owner purchased the property. And for a $200,000 purchase price, let's say the policy will be
probably around $1,200, maybe something.
$1,200, which can be a very sizable amount for some home buyer buying a home, adding $1,200 to their closing costs. So for $1,200, if you divide the $200,000 by 4, so really is only one that she took the $200,000, right?
Right.
So in this case, she will have to pay each one of the other 3 siblings that they haven't got portion of that sale price. She will have to pay them individually.
Right. Yeah, they'd each be entitled to about $50,000 on a $200,000 purchase price, and so instead of paying $1,200 at closing for peace of mind, later on down the road, she may be
spending $150,000 or give her the property.
Exactly. Another just real world example, things that actually happen. We had a case where there was a gentleman and he didn't have any children and his wife was deceased. And so he left a will and gave everything to his sister because that was his closest family member. And then he got a girlfriend after making that will and decided he'd do a new will, and our office did the new will where he left everything to his girlfriend. Well, the sister knew that, and when the gentleman passed away, the girlfriend was grieving. The sister had the old will. Well, when you do a new will, it doesn't make automatically a big red stamp show up on the old will. So she had the old will, went to the probate court. It looked valid. At probate court, you only have to give notice to legal heirs, which means blood kin or married individuals. So girlfriend got no notice of this.
Right.
And so the sister got appointed by the probate court as the executor of the will, got full title to sell the property, got a court order, listed it with a realtor who got all the paperwork from the probate court. So everything looked right. And the only reason why she got called on this one was because the closing happened to come back to our firm. And we were like, well, no, wait a second. We did a new will for this guy, and everything was supposed to go to his girlfriend. That's the only thing that, if they'd gone to any other law office just that had not done the will.
That's a tiny, huge problem.
Yep. And so if you had bought that property and then a couple of years later, the girlfriend never got around to probating the man's estate and trying to sell the property, you would have a big mess on your hands without title insurance.
So title insurance, remember that it's optional, but not for you. So one of the things I do actually monthly in my office, the confusion from buyers is when it comes to manufactured housing, or as they call it sometimes, mobile homes, right? So mobile home can be just treated as a real property if the paperwork is done correctly.
Right. And the key word is done correctly there, because it's very picky to get it done correctly.
Correct. So so a lot of times they just go on and they see that there's no wheels in the mobile home. They think it's actual real property. But there's a little bit more things that you got to do. And we got better at it at our office because we learned by our own mistakes. But you can explain it better to our audience, but would not scare them just by hiring the right professionals to complete the process correctly and researching it, of knowing when you buy a personal property mobile home versus a real property mobile home.
Exactly. So a mobile home or manufactured home, when it is first made, it is considered personal property. It has a car title. If it's a double wide, it has 2 car titles, and it is like a car. It has nothing to do with the real estate, even if it's parked there, wheels taken off, fully set up, until the title to the mobile home is retired and made a part of the real property. And that is a complicated process that nobody asked me how to do it, because if they did, I'd kind of change it up. But what you would have to do is you take those mobile home titles and you file something with the clerk of court stating for the record that you are retiring those mobile home titles. But even though that's recorded at the courthouse for everyone to see, it does not mean that the mobile home titles are retired yet. After filing that, then you have to take that paperwork to the tax commissioner's office, and they'll actually retire the titles, and then they will forward paperwork to the tax assessor's office. So there's 3 steps there, and oftentimes people do 1 step or 2 steps, but all 3 steps don't get done correctly. But once you do retire the title to the mobile home, it does become a part of the land, and it's much easier to buy and sell at that process.
And sometimes, but they just call the tax assessor's office and they find out about the tax bill being $100 and they get excited. And if you're not working with the correct lender, they will even base the mortgage payments on that $100 a year for property taxes, when that is actually a huge red flag telling you that $100 tax bill means
that means if you see
personal property.
If you see a very low tax bill, that means that the land and the home have not been combined yet, and so they're half of what they should be because they're not combined. A lot of things that will trip up some attorneys too, going back on this. They'll call the tax office and ask, hey, is there 2 bills for this, one for the home and one for the land, or is there just 1 bill? And even if there is 1 bill, that does not mean the home has been retired. In many counties, if you file for a homestead exemption saying that the mobile home is your primary residence, they will go ahead and combine the bills for ease of paying your taxes.
Right.
But that does not mean legally that the home and the land are together. So if you went to a closing and somebody said, I'm selling you this land, they're selling you the land, but unless that mobile home has been retired, you're not getting the house as well.
Correct.
And one problem we see a lot of times is before the home has been retired, there's a lien against just the home and a lien against the land. And the seller needs money to pay the lien off on the home because you have to have a free and clear title to retire it. So they need to sell the home to pay off the lien on the home so they can retire the title. But a lot of lenders won't fund a loan to purchase it, to give the seller that money to pay off that loan unless the thing's been retired. So you run into like an endless loop. You need the closing to pay off the lien on the home, but the lender won't fund the closing until the lien's been paid off.
Right.
But when we work with Miriam, we do not have that problem. She's got the process figured out so that we can fund the loan, use the money at the closing table to pay off that lien, and then once that lien's been paid off after the closing, get the mobile home retired. We take the actual mobile home titles, the actual pieces of paper at the closing table to make sure that our office has them and goes and gets those retired.
And we've done it many times, so don't let mobile homes scare you. We got it down to the science, and not that. Because the reason why many lenders, they would not do that, as you know, because it's a risk to us as a lender.
Mm-hmm.
So if eventually that process doesn't go through, we are literally giving a mortgage loan on a vehicle, on a car loan, pretty much. So, but we don't do car loans. We only do home loans. So that's where it becomes tricky, and it is an exception that we had approved years ago with corporate, and we are able to fund those transactions. And that's why many people reach out to us, because mobile home is easy when you know the process.
Right. If you know the process, it's easy. But if many law offices don't know the process either, and that's why a lot of lenders stopped doing it, because they were relying on the attorney to do it, and the attorneys weren't getting it done. So
one of the things is that what are the most interesting or unusual laws related to real estate that you think everyone should know about?
Well, one that's unusual and that I myself, as a first-year law student, thought was fascinating to learn about are adverse possession laws. So very generally, the law favors land being productive. We want property doing things. So you can't, if you own property, you can make restrictions on it. You know, some people will say this house or this property can only be used for residential purposes. You can put a restriction like that on
right.
land. But at least it's still being used for residential purposes. But the law wants property being used for something. And so if there is land out there and you go onto someone else's property and adversely possess it, like if you go onto someone else's land and says, this is mine now, after a certain number of years, if the true owner doesn't kick you out, it does become the person that's adversely possessing that. In a practical world, most people would find out that somebody's adversely possessing their land. In Georgia, it's 20 years that you have to do it. So, you know, if you haven't come by and checked your land for 20 years, then maybe.
Interesting. It's time to go and check it out.
Yeah, but it does come up in our real world closing situations where, say somebody, especially some of these older transactions when we're going back in the 70s looking for things, and there wasn't a deed ever done into someone's name. It just didn't get recorded, and back in the old days, they didn't worry about always recording things.
Right.
We can say, well, we can't find the deed into their name, but legally they have lived there for 20, 30 years. Nobody's tried to kick them out. By the rules of adverse possession, you know, they are the owners as well, even though
the handshake method.
Right. Even though they don't have the paperwork for it.
So that in my country, in Spain, is pretty much just very predominant, and here I think you guys call them squadrons.
Yeah, squatters is a little bit more tough, more difficult. Georgia doesn't have that bad of squatters' rights laws. I know Florida's been trying to clean some of theirs on. That deals with tenants and people who aren't trying to own. With adverse possession laws, you actually will own the property.
Yes. So pretty much, you know, that's something that, you know, you want to go and check your land. You make sure nobody's there that may claim your land as being the owner of it if they've been there for 20 years. So go and check your land if you have any land out there.
Yeah, a lot of people know Rockefeller Plaza in downtown Manhattan. They actually close the plaza off once every 7 years to make sure that nobody's sitting in the mass of people claiming that, because you can also claim an easement via adverse possession as well, and saying that, well, I own part of Rockefeller Plaza, so that's why they actually close it down, to make sure no one has that.
Nobody has access. Chap, if you could give a TED Talk on any aspect of real estate law, what would be the topic, and what the key message would you want to convey? Two
main points for buyers in a real estate transaction. Number one, we've already spoken about, is that title insurance. Make sure you get the title insurance.
Title insurance.
You want that. It's going to make your life much easier. Like any insurance, hopefully you never need it, but if you ever do need it, you're going to be very happy you have it.
Okay.
Second one, in our industry right now, we are seeing a lot more wire fraud attempts than used to. And in the state of Georgia now, by law, if your down payment at closing table is over $5,000, it has to be wired to our office. That's not my rule. That's not something I came up with. That's the state of Georgia and Atlanta saying that you have to wire those funds in. And what is happening is people are trying to hack into the emails around a real estate transaction. And if they hack in, hopefully they don't. We take a lot of efforts in cybersecurity to keep our emails safe, but there's a lot of emails that go around between a lender, a realtor, a law office, this person, that person. There's lots of emails in this process.
Yep.
And if they see one, if they get into one, they can see what's going on in the transaction, and they will actually forward to the buyers. Usually it comes from a generic Gmail account, like closingattorney@gmail.com, something that's not real.
It's not Chap Sweat's office email.
Right, exactly. But it'll say, hey, we're happy to let you know that you're clear to close. Here's your cash to close amount. Wire it to these instructions, and if you wire it to that place, that money's probably not
gone.
Coming back. Exactly, it's gone. It's a wire transaction. Immediately goes through. So it's scary out there, but just all you got to do, just make sure before you send any wires, just confirm those wiring instructions before you send any money to anywhere. Don't look at the piece of paper they send you, because they'll put a fake phone number to call and confirm. Go on the internet, Google our name, call the number you find on Google, and then confirm those wiring instructions. Most of the law firms around here use local banks. So if you see something telling you to wire money to New York or Los Angeles, that's usually a big red flag as well.
Absolutely.
But they can be very convincing. We had one client one time, and he was getting those emails, and they were trying to tell him that he needed to Cash App his down payment on his house.
Oh, okay.
And he came into our office, and even though I was talking to him in the lobby of the building that says Sweat Law Firm over the top of it, he was convinced that I was the fake lawyer, and this guy that he was texting on his phone was the real lawyer. But we finally got him convinced to send the wire, and we got it all fixed. But they can be convincing, so just always, before sending any wire, I send multiple wires with every closing. We send wires for payoffs, we send wires to sellers, we send wires to various locations. I call, make sure every one of those wires are verified before I send them, and buyers should too.
And that's what we do from our end. Every time that we have a closing, before they actually go to wire the funds, it's a requirement for them to reach out to us, to give them the instructions beside the ones you guys send them by email, to make a phone call to your office to verify the account number matching the documentation that was emailed to them before wiring the funds, because we have experienced someone wiring the funds to the wrong source. So that is one of the a must do. Like, it's non-negotiable. Thank you so much, Chap, for this moment. Thank you for answering all the questions. Now, if anyone in the audience would like to reach out to you for their whether real estate transaction needs or life needs, how they can reach out to you?
Our website is sweatfirm.com, SWEATFIRM.com. Our phone number is easy to remember. It's 912-522-2222. So 5 and then a bunch of 2s. But they can reach out to us. Both of those, our generic email account for incoming emails is info@sweatfirm.com. And we'll be happy to help them. We're the highest rated law firm based on Google reviews in Camden County, and we like to keep that reputation going.
Thank you so much. This was an honor. What's such great wealth of information to our community.
Well, thanks very much for having me.
Thanks for tuning in. If you like the chat, share with anyone who might find value in it, whether they're looking for a little life advice or they're going through the home buying process. If you or anyone you know are looking to buy a home, I'd love to help you navigate through the process. See you next time.